What's up, everybody? Welcome back in to another Lawyer You Know podcast episode. Trial by Media is the series. We are kicking off another episode, and this one is about jurors. What rights do jurors have in the trial process that makes it fair for them to do their civic duty? We want to protect jurors. We want to make sure jurors are up for the job that they have. It's very difficult, something they've usually never done before, never been prepared for. So what rights are in place to protect them? And to help me answer that question today, we have my partner Pete Sardis and our associate JD Patel coming on to specifically talk about the jurors because we want to protect their rights throughout this process. Because if we make it terrible on jurors, we're not going to have jurors at all, let alone good jurors, fair and unbiased jurors for these trials that we put before them to answer the ultimate question in these cases. So, Pete, why don't you just start off by talking about where we get jurors' rights and protections from in the trial process?
Where we get their rights from is basically the court administration rules and the judges themselves. That's really what protects the actual, what we call prospective jurors.
All right, JD, anywhere else you can find rules that protect jurors?
So jury instructions are a big place you can go to. That's where they're kind of standard. It sets out what the jurors shouldn't do, what they can't do. That'll help ultimately protect them and, let them avoid any consequences on the back end if they were to violate those rules.
Right. And I think a lot of it comes down to when we talk about what the procedures are in court, what the rules are for jury, what the jury instructions say, it maps out what jurors can and can't do, but also what everybody else can and can't do to and about those jurors, right? And that's a lot of what it comes from is jurors have to be protected throughout the process so they don't have any outside forces that make them not a fair and unbiased juror, which is what everybody wants throughout the process, what everybody's looking for as far as lawyers go. When we go through the jury selection process, that's most important to us. So let's start off by talking about the number one most important thing when it comes to jurors, and that's anonymity. Everybody thinks all jurors are anonymous in all jurisdictions at all times. Is that actually true?
No, it's not. And in fact, depending on what state you're in or whatever federal district you might be in will dictate what the actual rules are for the way that the names of the jurors or the prospective jurors are handled. For example, in some states, all of the names of the prospective jurors for a particular case are public. They're part of the public record. In some other states, the names of the prospective jurors, the lawyers find out as soon as they walk in the courtroom, and there is no ability to do background checks on them. There's no ability to remove the names of those jurors out of the courtroom, to go, social media stalk them, for lack of a better term. So it really depends on where you are, and that's going to dictate how a juror is treated from a perspective of anonymity.
So what's interesting, we'll get to you in just one second, JD. I mean, when we try cases in state court versus federal court, the rules are completely different about what kind of research we can do on jurors when we get names, how big the pools are, and things like that. So just in our same state, the judge protects what the lawyers can do as far as doing background checks and questions you can ask of the jury when just comparing state and federal court. What were you going to say, JD?
I was going to say the first time like an anonymous juror was actually impaneled was not until 1977. And that was a case, like a federal case, where it was basically a large drug trafficking network. And that was, the purpose of it was 15 co-defendants. And the purpose of it was, to avoid any impropriety on the part of the defendants, anybody related to them, to protect those jurors. Because they, there's a process that the court has to follow. And if those steps and those factors aren't taken into account, then the judge won't, grant the anonymity of it and keep those names, sealed essentially.
So Pete, let's say we're in a jurisdiction where jurors' names are not anonymous and it is a public record. Is there a way for a high profile case, since we're focusing on cases that the media is all into, high profile, posting about it, YouTubers talking about it, podcasts about it, articles being written about it, news covering it. Is there a situation where that jurisdiction could make the jurors anonymous, the potential jurors anonymous, make it not public record?
Yes. And it always goes back to the judge that's handling a specific case. So if the lawyers were to go to the judge and say, I'll give you an example. Judge, if we release the names of these prospective jurors, they're going to have media persons all over their front yards. They're not going to want to serve on this jury. It's really going to cause a lot of problems to get a fair and impartial group of people to judge this case fairly. There is a better chance that a judge will say, even though this state requires that they're public, I'm going to seal those names, or at least temporarily until this case is resolved.
And I think you said, Pete, one of the ways where we get rules and rights for jurors is by court order or from the judge. And I think that's really the number one way that this stuff is. Now, it's codified in different states, different ways, like with anonymity, or that it's public record, because they want this to be a transparent process. And they think, some states think that that's a more fair and transparent process if the potential jurors are publicly known, public record. So somebody could come out and say, I know that guy, he wanted Brian Koberger to get convicted or whatever it is. Then I do think that being part of the process can be fair. But I think when it comes down to it, in the interest of justice, when it needs to be anonymous, when they need to be protected, a judge can step in and make sure that's the case, and lawyers can ask the judge to do that. So I think all of that is important. What about when it comes to, in the courtroom, cameras and microphones being on jurors? What is the most common way that courts have handled that? How do you think it's going to be handled in the future, with more cases being publicized and being on TV? For the most part, cameras aren't allowed to film jurors. Do you think that's going to continue? Where does that come from?
I think the short answer is yes. I mean, I don't think that jurors will ever be filmed in the courtroom. I know that in certain jurisdictions, I know Tennessee, California, during jury selection, for example, there's no media coverage that's allowed, right? So that's at the very beginning part of the process. Obviously, that'll change a little bit during the course of the trial when media is allowed to be present. But I mean, going forward, I think for the protection of the jurors, I think it's best that they not be actually filmed and taken, photographed.
Photographed,
Photographed, that works.
Yeah. And I think it's important, because that they don't wear masks. They're not behind a screen. If you go to the courtroom, you see the juror. You see them. So it's not like they are really anonymous or hidden. It's just, we don't want to make them part of the public spectacle. We don't want to make them part of the entertainment. We don't want people around the world, because as we've seen, this is why we can't have nice things, right? When people are given an inch, they take a mile. If people see jurors that look a certain way, or sit a certain way, or whatever, they're sleeping or they're not paying enough attention, that's what would happen. They would be scrutinized. This is not their job. It's different for a judge or a lawyer or even parties. Sometimes jurors are very different. This is not their job. They're doing their civic duty. They should not be, I don't think anybody should be berated by the way that they look or the way that they speak or things like that, but it is just different for these jurors. So it makes sense why the court would step in and not want them filmed. In every trial I've watched and covered on YouTube, the jury is not allowed to be filmed. There have been situations where it'll pan across and maybe you'll see them, or accidental viewing of them. But that's why we have, gag orders and media rules in places like Koberger, Gwyneth Paltrow, Vallow Daybell. A lot of these cases have these court restrictions on what media can and can't film. And for almost everyone I've seen, they say you cannot film the jury.
And interestingly enough, I'm sorry, go ahead, Peter.
No, go ahead.
I was going to say, and the media actually has an organization that kind of protects media's rights. They've actually put together, for any media individual, you can go online and find this, a list of all the jurisdictions and all the local rules for those particular jurisdictions that say, yes, you can film witnesses. No, you can't film jurors. And they've actually produced that for them. So all the media folks know what they can do and what they can't do, jurisdiction by jurisdiction.
And where I was going with that is, I was going to say, but every time we've heard verdicts read or polled the jury, I have heard the voices of the jurors. And again, they're not completely anonymous. And when later jurors are interviewed and they say, I was juror number 8, if you go back and watch YouTube and listen to when the judge says, juror number 8, is this your verdict? You can tell, is it a male voice, female voice, high, low, whatever. And, that is something that is publicized on YouTube and through the media being streamed. So I just think that that's interesting, and that they're not completely anonymous, hidden to where we would never be able to figure anything out like that, especially because obviously we can go sit in the courtroom and see what the jury looks like. So when we talk about jury protections, right, and we talk about cameras and microphones and where those protections are, what do the other protections look like that judges usually put in place, or rules in different jurisdictions put in place during the trial, after the trial? Can they be berated? Can they be stalked and followed? Does the media know where the jury lives? If they're sequestered and staying at a hotel, does the media know that? How do we protect jurors in those situations?
So there's a rule that the judge basically says at every break, any recess, stuff like that. If any outsider media, anybody tries to talk to you, tries to bother you, they're supposed to tell that person that they're a juror on a case and that they can't take any information. They have to refuse to listen to them, and if they keep persisting, they ultimately are going to report it back to the bailiff, who will then tell the judge, and then it becomes a whole ordeal in that sense. So that's one big thing that the jurors are supposed to do. I know I've had cases where, the jury sometimes even a juror has done something and they've sought out outside information. They've talked to somebody, they report it back to one juror, and it ultimately goes to the judge, and it's reported as a mistrial. So they're held accountable for the actions that they do.
Yeah. Other than a criminal defendant, really, the courts protect the jurors, and they try to make it as pleasant, if I can use that as a term in this context, as pleasant of an experience it can possibly be, since you're being taken away from your work, your family, all the things that you would normally do day to day, in order to come in and listen to this case and make a decision. So the judges are very conscious about making sure that their comfort is met, that the media and the lawyers and the parties know, stay away from these people. They give them little buttons in a lot of jurisdictions, say juror. So when they see that red button or whatever the case may be, people stay away from them. But the problem is, if the jurors are known, can the media go to their homes? The answer is yes, unless the court has specifically said no one bothers these people during the course of that trial. It's not just a carte blanche rule across the board. So again, it's jurisdiction by jurisdiction, but most courts, I think, are going to frown upon media camping out in front of jurors' residences. I'll tell you, now we're going back to the murder trials from the 1990s, when you've got jurors literally walking into the courthouses, and there are cameras and reporters walking next to them, actively asking them questions about who they are, what they think. Do you think you're going to get chosen for this jury? And I think a lot of the rules that we take for granted today actually stem from that time when the media was a little bit more prolific in their ability to communicate, touch, and affect jurors.
And I think in most cases, judges these days are telling media not to do that. So while there might not be any rule directly on point, I know in the Rittenhouse case and the Johnny Depp case, the judges actually told media not to do stuff like that. And it was proven throughout some cases that some media was sent to find these jurors and follow these jurors, and cops figured it out. Law enforcement got involved, and they were reprimanded by the judge, and it became a whole ordeal. And I think that that's probably going to be more of the norm, because if the jurors are feeling this pressure by the media, and they feel like, especially if a case is overly politicized, or somebody hates a criminal defendant and convicts him in the court of public opinion before it actually goes to trial, now we are infringing on the criminal defendant's right to a fair trial, which is what all of this comes down, and how media can affect it. It is trampling on jurors' rights and then making them feel that pressure. And at that point, now there could be some sanctions by the court. And again, what was the case that I just did? Austin Ford's mom, who took pictures of the jury after the court told her not to, and she was sentenced to 3 days in jail for it. So there are legitimate circumstances and sanctions where if you violate the jurors' rights, and their right to anonymity is mostly, or their right not to speak about the case, if you keep stalking them and pushing them, you can actually get punished for that, right? I mean, even the media can get punished for that, right?
Absolutely.
Do you have any instances or anything that you found of media sanctions? No?
JD, you got anything?
I did not.
I will tell you, I did. And it's back again in the 1990s. And again, of course, because I'm getting old, his name escapes me. Football player accused of murdering his wife. Come on, guys.
OJ?
Thank you. And it's been that day. In the OJ Simpson trial, the prospective jurors were basically harassed by the media. And Judge Ito at the time had actually issued an order, and that's why all those folks were sequestered, because they were being hounded. So he basically took the media away from the ability to have contact with those jurors. Now, understand, imagine being in a trial for 15 weeks, stuck in a hotel room, going back and forth, being escorted by law enforcement. That was a bad way to be.
Yeah. And in cases we're seeing today, the sanctions for the media is you're out. We're taking your cameras. We're taking your recordings. You're out. You're not going to get the access. You're not going to get the clips. We know you're making money on this. That's your sanction. And then also, because usually it's not one individual person or a camera operator, you don't really want to throw a camera operator in jail who's probably listening to somebody much higher up. Same thing at that other trial I was telling you about. The person going out to search for the jurors was not the boss making the decision. They were doing their job, unfortunately listening to bad advice from a boss. So, usually that's not going to be a direct individual person, but it could affect then future cases, how that court, how that judge, how that jurisdiction looks at the media. And that's the ultimate sanction, is restricting or removing their access to the trial. And that is absolutely appropriate, because they are going to be able to say what I just said. If the court finds and has findings that this is affecting the criminal defendant or the prosecutor's right to a fair trial, which we already did on a previous episode, if you're infringing on those rights as the media, they will remove your access, because a fair trial is more important than public access by the media. Doesn't mean they're going to close the doors. They can just take out all the cameras and microphones, and you can still have reporters sitting back there in the gallery. And that is the least restrictive manner in which they can remedy this issue. So that is a sanction to the media if they do violate these rights of the jurors. And it does step on the right to a fair trial. So a lot of what we've been focusing on this first part of the podcast is the rights of the jurors to be protected from the media, from the gallery, from outside influence. But there are also rules that restrict what jurors can do, and that can be affected by the media. And it's getting crazier and crazier every trial because of how much of these cases are on TikTok, on YouTube, on Twitter, on Facebook, whatever. It's so much harder for them not to see anything. So when we talk about, let's kind of break it up into parts. So for now, we'll talk about prospective jurors before you become a juror. And you have access to this stuff. You haven't been sequestered at this point. What are the rules as far as prospective jurors in accessing information or seeing things on social media or on the news about a case for which they are a prospective juror?
Go ahead, JD. Okay. Go ahead.
I mean, the rule is don't use any electronic devices or don't go on social media. If you see it, go to the next page, avoid it at any cost. I mean, that's the idea, is you're not allowed to get any information outside of the four walls of that courtroom. That's where the evidence should come from the stand, from all the evidence presented, nothing from outside, because both parties, the prosecution and the defense, don't get a chance to rebut that information and argue whether it's right or wrong if they don't know what it is.
Right.
So,
and that I think is during trial more. That's more an instruction for during trial once they've been impaneled. But go ahead. And maybe you're not getting, my question was confusing, which I can answer it. But Pete, go ahead.
And the answer is, and normally when the jury pool shows up in front of a judge for the first time, the judge will tell them what the case is about, and they'll read the facts of the case. And the question will be, has anybody heard about this case? And the judges are very good now. This has changed over the course of years at looking to see who reacts. And then they're very conscious. They see a lot of hands go up because something's been very public. They will stop those jurors, and they may, either bring them up to the stand one by one to find out what they know, to avoid tainting the rest of the jury pool. So that's kind of how the judges start, is, has anybody heard of this? And if the answer is yes, don't say anything more. We're going to bring you up to find out what you've heard, to determine whether or not this is somebody that's already been tainted so much that they can't be fair and impartial.
And I think the rule and what the juror has to do at that point, if they're a prospective juror on a case and it's everywhere on social media, all you really have to do is be honest about what you've seen. Mm-hmm. Be honest about what you've seen and how it's affected your opinion on a case. Tell the lawyers that, tell the court that, and then they will make a decision, and then the chips will fall as they may. That's really the juror's only requirement. The problem comes if you lie about it and you say, oh, I haven't seen anything, when you have. And maybe you've commented on a post and somebody can find that, because lawyers these days in high profile cases are going to be looking at stuff like that. They're going to be looking at names. Now, what makes that even more difficult is when somebody has, and I'll just use this screen name that I know one of our subscribers has, the lawyer you don't know. If that's your screen name, well, I don't know if that's John Smith or Peter Tragos or whoever that may be. So they may not be able to connect that comment with you. But if they ever do, and they find out that you lied about seeing things on this case that could create issues. Okay. Especially if it's things that would lead them to believe, like you make a comment like, oh, he's guilty of sin or whatever it may be. And then you end up on the jury. Well, that media article that you saw clearly affected your ability to be fair and impartial. You have already prejudged this case. So did you give honest answers through the voir dire process? And if that answer is no, now it could create a mistrial, waste so much time and money for people, and we'd have to redo this case all over again.
And again, you're risking being held in contempt by the court.
And that's what I was going to say. So let me ask that question so people can understand what we're answering. So one remedy and horrible thing that can happen if a juror does lie and makes the wrong decision and breaks the rules is we have to do the trial all over again, mistrial. But what are some other consequences that may come from jurors lying throughout the voir dire process?
I mean,
Pete, go ahead with what you were saying.
Well, I was going to say, you can be held in contempt, meaning that the judge can actually find that you have affected the interests of justice and can either fine you, can send you to jail.
Did you have something to add to that, JD?
Nope, that's it. Yeah. I've had cases where the judge completely embarrasses them in court, makes them cry, almost puts them in jail. I'm surprised she didn't in one of the cases, but they do what they want to do ultimately, but it's bad.
Right. Exactly. And I think that that's not a bad thing. That is not something that I think is unfair. Again, we're talking about people doing their civic duty. We want them to feel comfortable. We want them to feel appreciated, but you can't break the rules. And that's really, really an important part about it. So once we actually get into trial and jurors so let's talk about witnesses are sequestered. And when we talk about jury sequestration, usually we mean they are in a hotel room away from everybody, no cell phones, no access to the internet, no TVs, no family members. That's jury sequestration. And that point, they can't see anything. That's got to be a super high profile case, rare circumstances that we do that. We saw it in the YNW Melly case when they just did it for the verdict portion or when they were deliberating. OJ, they did it the entire trial. It's unusual for them to do it. Sometimes lawyers ask for it. It's rarely granted. But generally, jurors are sequestered throughout the process. And kind of like what JD said, they're given an admonishment not to look at anything. If it does pop up, move to the next, but also report that you've seen something. And if you're a juror, the rule really is, in an abundance of caution, let the court, let the lawyers know what you see throughout the process and just let them make the decision. Because again, if you do the wrong thing or if you don't, if you're not honest with the court and it creates problems later, you could be looking at sanctions. You could be looking at a mistrial. You could be looking at all these problems that you really don't want to deal with. And talking post-trial again, okay, and kind of reverting back to the rights of jurors to not be bothered. Are there jurisdictions where they force interviews with jury members to talk about what they discussed in deliberation rooms?
Forced, meaning obligatory?
Correct.
I don't know anyone that obliges a juror to speak to anybody.
Yeah, not that I'm aware of either. Nope. Most say you don't have to, but it is up to you. Mm-hmm. Are there any jurisdictions you know of that say jurors cannot give interviews, are not allowed to?
Post-verdict?
Yes.
The answer is they've tried, but the appellate courts, they all kick it back saying it's a violation of First Amendment.
Right.
And that's in almost every jurisdiction.
And that makes 100% sense to me. This is not something they signed up for or wanted to do. It's not their job. They were told they have to show up for jury duty, literally. And if you get picked, you can't then restrict their First Amendment right to free speech post-verdict. This is something I did. This is something I'm going to talk about, and I can if I want to. So jurors have the right to talk about these cases afterwards, right? And have you seen any problems with jurors exercising the right to discuss it and do interviews after trial? Have you seen any problems with that?
Absolutely. And in fact, there are huge problems. And a lot of the case law that surrounds this topic is because the jurors went out there and said something like, we couldn't decide, so we flipped a coin. I'm just using this as an example. Well, clearly that's not a unanimous verdict if you guys couldn't decide and you had to flip a coin. So now it causes a question about the validity of that particular verdict, which means you got to bring everybody back. The court's got to do voir dire, meaning ask questions of all the prospective jurors. And if it comes to find out that something that happened inside of the deliberation room during the decision-making process of the jurors is against the rules, they may mistry that case, set aside that verdict, and have to try that case all over again.
Yeah, I don't know if it's that it wasn't unanimous, but it's not based on the evidence in the law. I mean,
Whatever
that's
the case may be,
right,
there's a
right,
number
because
of
they can all
different things.
unanimously agree whatever way the
Right.
coin flips. But
Yeah.
did you have something else, JD?
Now, I was going to say that during the, I think it was 1980s and 1990s, they actually allowed, I think it was PBS and CBS to film jury deliberations. So it
that
was
would be awesome.
In 1986, jury deliberations in a Wisconsin trial were taped, and they were used on a episode of PBS Frontline. And then a series of criminal cases in Arizona, CBS was allowed to film it, and they called it like Inside the Jury Room. Basically, every party had to sign consents, the court, the parties, all the jurors. They waived their right to appeal based on anything like that for use of the film. But it basically got an inside look at, how a jury deliberates. Have you seen the new documentary called Jury Duty on, I think it's Amazon Prime, maybe?
I don't think it's a documentary, but I've seen a couple
Right,
episodes.
what
I
I mean.
haven't watched the whole thing, but yeah.
I mean, it's crazy is what it is. I mean, I don't think that's realistic, but, it was
No,
funny to
I
watch.
mean, it's probably more realistic than people would want to believe on some trials, but mostly that's not the case. It's just a bunch of, like, they planted one real juror with a bunch of actors, and he thinks he's there for a real trial and real jury duty, and it's absolutely wild. I do have to finish it though. I started it, but I haven't finished it. So that's interesting that they would waive appellate issues, because I mean, you wouldn't have that information anyway. So I think that makes sense to waive the appellate. At first I was like, why would any criminal defense lawyer do that? But it's like, you wouldn't be privy to that information anyway. So it wouldn't be something you could use for an appeal, unless of course a juror comes out and testifies to it. What were you going to say, Pete?
It's funny, years and years ago now, when one of my maybe first handful of trials in criminal court, I actually had a not guilty verdict. And the judge, because the prosecutor was also a young lawyer, as was I, relatively inexperienced, both of us. And the judge asks the lawyers if there's any appellate issues. Since it was an acquittal, there were none. And he says to the jury, okay, if you guys both waive, I'm going to let the jury tell you what their perceptions were of your performances and what they thought about the evidence, just as a teaching tool. And it was really neat to hear the different jurors' perspectives on what they saw and kind of what they thought was important during the course of the deliberations. So what JD's talking about, the ability to look inside of that jury deliberation room, is like, what lawyer doesn't want to be there watching what goes down?
100%. And I think that it is also, so it's an interesting thing to me. And I want both of your opinions on jury interviews and whether or not you think they should occur, whether jurors should do it or shouldn't do it. Cause I've kind of gone back and forth on it. But in the Ghislaine Maxwell case, which is Jeffrey Epstein's associate, she was convicted in federal court, not televised, but a juror came out and talked to some people, gave some interviews. And it turned out that they, I don't know if lied is the right word, or put a wrong answer that they swore to under oath about being a victim of a similar crime. They checked no, but the true answer was yes. And they came out and told people that afterwards. And there was a big hullabaloo about it. They had a hearing. The court had to give them immunity. They hired a lawyer before the person would even talk to the court. They ended up talking to the court, and the court did not overturn the verdict because of this. But that's a big deal. And giving incorrect information, and then nobody would have ever known about that had this juror not given the interview. But at the same time, would that actually change the outcome? And do we really want to try a case like this all over again? But every right is important to a fair trial for the criminal defendant. So what do you think about juror interviews? Because I can kind of see arguments on both sides where, yes, we want them because more information is better. But at the same time, it's like, are they really speaking for everybody if just a couple jurors give interviews and not everybody does? So Pete, we'll start with you.
Okay. In a lot of jurisdictions, there's normally two rules. Either a juror can be contacted, and if they don't want to speak, you can't bother them ever again. So as a lawyer, you have the right to make a phone call and say, hey, you were a juror on my case. Would you give me some feedback? You're allowed to do that in some jurisdictions. Other jurisdictions, like Florida, says the lawyers can't reach out. But if the jurors reach out to the lawyers, they're able to ask questions and kind of figure out what's going on. And the couple times in my career that jurors have actually called and given us feedback, it's been, I think, the most educational moment. Like, you kind of actually see what everybody was thinking, because you kind of, as a lawyer, you think you know how your case is progressing. You've got your, the way that your proffer of evidence is going to go down, but then you get to hear how somebody else actually received that information. It's huge.
It's
but
awesome. It can't be overstated. And that's why when we watch these on YouTube, like the juror interviews, you learn so much about what's important in the case.
But you have to be careful, because the next side, the flip coin of that is, you learn so much stuff sometimes that it's bad, and it opens up appellate issues. It now causes all kinds of trouble. And if there is a reason for a judge to overturn a conviction or to overturn a case in its entirety, set aside a verdict on a civil case, because something really happened that was inappropriate, I want to know about it. It just, that is what it is. But at what point and how far deep do you dive into, like, for example, I opened up my I don't know, my email because we were at lunch, and I saw the headline on one of my posts that said the jury's out to lunch on the case. Well, did that really taint anybody? No. But is there a way that we can make a mountain out of that molehill as lawyers? Absolutely. Drag the juror back in, stick him on the stand, talk about, what did you see? How long did you see it for? How did it make you feel? So there has to be some finality. So I like the idea.
We'll always try to find something if a juror talks.
Of course. And that's what you're doing. You get a juror to talk and you try to find a problem, a violation of a rule, a jury instruction, a violation of something that could potentially be an issue to bring back in front of the court. And now you're really making everybody's lives hard, because now you're bringing jurors back in and having entire mini trials about what they saw, what they heard, how it affected them, all that stuff.
And what do you think, JD?
I mean, I'm a fan of it. Truth be told, I love, like, when I'm in trial and we get the opportunity, or the judge gives the jury the opportunity to ask questions from a witness, because I get to know what's in that juror's mind at that particular moment. And me and Pete just had a trial back in June, and the judge allowed, the jury to ask questions. And some of the questions were like, okay, great. We know exactly where the jury's sitting at this point. Obviously we wouldn't know that after the fact if, during the interview, but at that particular moment, it's nice to know. And I think just, over time, knowing what a juror thinks, how they think, what their steps are in the back in the deliberation room, I think it's all key. I think ways that the judge in the court could probably, limit it is by preventing jurors from talking about other jurors. There courts have held in federal court, I think Fifth Circuit, they're allowed to prohibit any juror from talking about other people's stuff, like the way they deliberated, but just you can talk about you, and that's it. So, I mean, that may be the better way to, handle these situations to protect jurors who don't want to speak.
Yeah, and I think that happened in the Y&W Melly case when they all were kind of talking about the one juror that was a holdout and flipped other jurors and things like that. From my perspective, where I land right now is I'm also a fan of it, because more truth and transparency and just dealing with the truth is better than just not knowing and therefore not creating other issues. I'd rather just know the truth and we'll deal with it. And if it was done the wrong way, then was that really justice? We can't be scared of that. We shouldn't want to trick jurors. We shouldn't want them to be confused or not knowing what's going on, even if they rule our way. I know some lawyers will probably disagree with that, but that's kind of how I see it. I'd rather just know the truth, honestly, regardless if I disagree with the jury's verdict or things like that. I think knowing is more important, and learning from that is more important. And I am a fan of them as well, the juror interviews, but I definitely think it should be restricted to what they know, what they thought, what they saw, what they said, what they felt was important, and things like that, because I do think it is a really good tool for everybody, for the public to understand, for judges, for lawyers to understand how jurors think about this process. And I know the Vallow Daybell case, a juror was interviewed and there were arguments made that they didn't understand 404B, other bad acts evidence, Williams rule evidence, and how that created a problem, when in reality, it's not really how it was. And I think, like Pete said, the losing team was just making a mountain out of something that really wasn't that big of a deal. So I do think that stuff is important. I think it'll be fleshed out appropriately, although I do think it can cause delays, which is always annoying. The last question I have is, in case anybody didn't notice, when I asked the very first question about where rules come from and where rights of jurors come from, and there was kind of a pause, and then there was kind of a this, that, the court, some procedures, some jury instructions. Do you think, with the trial by media theme, all the media attention, the cameras, the microphones, social media, people putting things out there in the public, do you think rules need to be codified more specifically for juror anonymity or public record type deals, for what can and can't be done and said to and about a juror, what can and can't be photographed and filmed and recorded about a juror? Do you think there needs to be some rules in place as we go forward? Because that's how we look at it. On the rules committees, We talk about what's happening in the future. What rules do we actually need? What are things that are happening that didn't happen in the past? That's why we don't have rules for them. We don't really want more rules, right? Unless we need them. Do you foresee this happening in the future, Pete? Us kind of coming up with more rules specifically that so it can be more uniform on how we deal with jurors?
That's the hard part, is uniformity, because technically every jurisdiction has sanctity over their own policies and procedures. And I'm talking about from every judicial circuit to every state, and the federal courts are separate. So it's difficult to codify something so it is completely the same across the board. But I think what we are seeing is that the rules are starting to become more and more similar, because as time progresses and as media changes, the court system is slow. We've talked about that, but they start to learn and they make adjustments based on how the media exists at a particular time frame. For example, who would have ever thought that anybody with a cell phone could technically be media? You can go into a courtroom, use your cell phone, and film anybody. You can post that on social media instantly. Frankly, a person with a cell phone is more effective than actually going through your traditional media outlet, because there's nobody filtering that stuff. So I think there's going to be a time where they do start making more definite rules and definite statements. But I think you're always going to have variation between states and between the state and the federal systems. It just always will be.
Yeah,
KD, what do you think?
I completely agree. I mean, there's going to be a point in time where I'm sure the Supreme Court will ultimately rule. There's going to be an issue that gets to the Supreme Court, and they're going to rule one way or the other. I mean, it's probably about time they do. I think the last time they've made some serious, law and rulings was probably, 90s, early 2000s. Since then, the media has changed. The way these cases are filmed and the way they're going through is a lot different than before. So I think that rules are going to be coming into play, or rulings from the Supreme Court at least. But I think the committees among each jurisdiction are going to have to start, at least setting something in stone. That way everybody can start following those rules.
And so that we don't have to have arguments in every case. Like, there are certain things that need to be a case-by-case basis. There are other things that really don't. And I don't think jurors' rights and how we deal with jurors and protect jurors, what they can and can't do, what the outsiders, the media, the gallery can and can't do, that I feel like could be pretty similar. We're already talking about stuff like this on rules committees, on the civil rules committees in Florida, how to deal with the media, how to deal with cameras, how to deal with the social media in cases now. And so I think it's only a matter of time before we have more rules in place on how this stuff should be done. And I think we're kind of, case law and how things are done and how decisions are made based on a case-by-case basis usually formulate how the rules are written. And I think we are going to look at these cases that are happening right now, the decisions that are being made, what works, what doesn't work, and try to form rules based on that. And that's usually how it does work. So I appreciate you guys joining me today. We have hit jurors' rights throughout the process, throughout the trial process, the pretrial process, and how it all comes together with the media, the trial by media, and of course, coming up with a fair trial at the end of the day for the parties involved. So Pete, JD, thanks for joining me. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.